Okay, so first of all, let's just jump in with this disclaimer first. I'm a true crime channel. My videos are for educational purposes and for adults only. I don't do clickbait. I don't do live streams. My videos are pre-recorded videos where I talk about current cases. In this video, I'm talking about the Madeleine Soto case. For anyone who may have actually not heard of it, Madeleine Soto was a 13-year-old girl who went missing only a few days after her birthday in 2024. It was later discovered that her mother's ex-boyfriend was responsible. And now he's locked up, facing 2 trials, one because of images found on his phone, and one for Maddie's death. So, I was almost a day late with my latest video, as you will have probably noticed if you are one of my regular viewers. And I figured, well, hey, at least I'll get that done early, I'll count that as today's video, and take the rest of the afternoon off. And then I thought, it's been a few days since I actually had a look to see if there's any new documents out in Sterns' case. And turns out there are. So I think many of us have been a little bit concerned over the motions that have been put out by the defence team, which would basically put an end to the CSAM case completely. They were trying to have all the phone evidence thrown out and all the Google evidence thrown out, claiming that the phone was seized illegally, it was downloaded illegally, and that therefore the contents of his Google Drive were inadmissible because, of course, they were claiming that, well, the phone evidence is inadmissible, and because of that, that's how they came onto the Google Drive, so that would therefore also be inadmissible, just in a nutshell. So, last week, another creator put out a video where he cited his credentials, and I think I watched about 5 minutes of it, and he was basically saying, well, you know, I agree, it's all illegal, this could be thrown out, they've made a huge mistake. And I was going to work on a video which was going to show that that is actually incorrect. And I had a handful of documents, including Myra Tagler's report, which I will upload to Patreon after I upload this video. So her report about the interviews. And it's pretty clear when you start to look at it all together that actually, no, they were well within their rights with what they did. And no, Detective Tagler didn't do anything wrong. So I was going to do that video. I got a bit waylaid covering the other videos that I've done this week. The plan was to get the latest Jennifer Soto's videos out of the way and then come back and talk about the phones. In the meantime, as I've said, the state has now filed their response to the motions which were filed by the prosecution. Now, this is going to be a lengthy video because I think it's worthwhile to go through all 3 documents back to back because they all do connect. That said, what I will do is I will pin a comment at the top of the comment section with all the timestamps. So basically I'll give you timestamps for each of the separate documents. That way, if you want to just listen to one at a time and come back to it, then, I mean, you're your YouTube should probably take you straight back to where you leave off. But if not, then the timestamps are there and you can just go directly to the timestamps. So along with Detective Tagler's report, I will also upload these 3 documents to my Patreon. For those of you who are new to my channel and not familiar with how I run my Patreon, it is entirely free. There's no cost for membership, and any documents that I put up there are also free. I have put a few tiers in, so if you feel like you want to provide a bit of support for my channel, there's a $1 tier and a $2 tier that you can join if you wish. But if you just want to get the documents and you don't want to have to faff around, or you don't want to have to pay for them, then hop in, join my Patreon for free, upload the documents for free. There's now quite a number of documents there on my Patreon. There's still a heap more that I need to upload. And as I mentioned the other day, I've been a bit lax with that. I've been so busy fighting with this demonetisation stuff that Patreon kind of went on the back burner. But as soon as I get this video uploaded, I will put those 4 documents up for you into Patreon. Now, one last thing before we jump in. A few people have made comments because of the issues I was having with demonetisation and everything, that they wish they could support me more. And my comment to that is, if you are subscribed to my channel, if you are hitting the like button on my videos, and if you are leaving a comment on my videos, that's all the support I need from you. Because that then helps me to grow my channel. That helps me get my videos out there and seen by more people. And, with the ones that are demonetised, just by viewing my content, you're helping me to earn a little bit of money off my channel. So, with that said, let's just jump into these documents. Now, before we do, I will just say I haven't read them through myself, but it appears to me that because they are all interconnected, that they've doubled up in a few cases in terms of background information. So it looks to me like a lot of pages, but I think that we will find as we go along that some of it is doubled up, so I won't have to read through that. So on that note, let's just get into it. Okay, so all 3 documents are from Assistant State Attorney Danielle Pennell. If you've caught some of my previous videos, you'll know that she is far more efficient in her work than old Lizzie Borden, Beth Burden. So I think these should be a bit more bearable than trying to slog our way through any of Lizzie's documents. I think what we're going to find is where she's got procedural history, I think that's going to be repeated throughout. So this first one is State's response to defendant's motion to suppress evidence obtained from unlawful searches of cell phone. Comes now, State of Florida, by and through the undersigned Assistant State Attorney, and hereby states as follows. Procedural history. The defendant was arrested pursuant to an arrest warrant in the above-styled case on February 29th, 2024. On March 11, 2024, the state filed an information charging the defendant with 8 counts of S battery on a child under 12, 5 counts of S battery with a child 12 to 18, 7 counts of L and L, that. Sorry, you'll have to read that bit for yourself because I'm not sure how to say that without getting nailed, and 40 counts of unlawful possession of materials depicting S performance by a child 10 or more images. Okay. The state provided discovery to the defendant on March 20, 2024, and discovery has been ongoing. On February 6, 2025, the defence filed defendant's motion to suppress evidence obtained from unlawful searches of cell phone. The motion alleged violations of the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution. Statement of facts. On February 26, 2024, Madeline Soto was reported missing to the Orange County Sheriff's Office by her family. The family contacted law enforcement at approximately 4:30 p.m. There were 3 calls made to the Orange County Sheriff's Office prior to deputies arriving. At approximately 7:35 p.m, Deputy Frank Joseph with the Orange County Sheriff's Office made contact with Jennifer Soto, the defendant, and members of Ms. Soto's family. All individuals were present in the lobby of the business building in which Ms. Jennifer Soto's mother worked. Deputy Joseph inquired as to the identifying information for Madeline from Ms. Soto and the family. The defendant stated he had dropped Madeline at school that morning. The defendant described that Madeline had been wearing a green hoodie, white Crocs, and either blue or black pants. Deputy Joseph also was told that Madeline had not taken her cell phone. Okay, there's mistakes in this document. After me praising Danielle Pennell, there's problems here. But, I mean, this is not legal, the legal side of it, so that's okay. It won't be okay if she makes these mistakes in court. Deputy Joseph also was told that Madeline had taken her cell phone to school that day, or had not taken her cell phone to school that day and only had her computer. At approximately 7:47, Jennifer Soto provides Madeline's phone to law enforcement to review. Actually, she provided the phone the following day to Detective Hunt. Sworn written statements are collected from the defendant and Jennifer Soto on February 26, 24. The defendant's sworn written statement states as follows. I'm just going to say this now. On the off chance that anyone from the State's office is watching this video, if you need someone who actually knows the case to proofread your motions, please feel free to hit me up. Right, states as follows. Dropped off about a block or so from school, sometime between 8:25 to 8:40 a.m. Turned around and headed back towards town. I watched in my rearview mirror as she made her way in the direction of school. She was busy searching through her backpack for something, but seemed to still be moving towards the school. So I carried on with my day. I stopped by a nearby vape shop, but it was closed, so I went home and left about an hour or so later to check the shop again. It was open, so I bought my vape juice and returned home. Relaxed with Jen for a while. Later went out in the afternoon for a few more errands and returned home around 2:30. Jennifer Soto's written statement states as follows. Today, around 8 a.m, I saw Madeline getting ready for school. I'm not sure what time they departed. Stephan Sterns took her to school and dropped her off close to school on Town Loop Boulevard between Town Centre Boulevard and Hunters Park Lane, around 8:30 to 8:45 a.m. She never made it to school. I went to school around 4 p.m. to pick her up and she never came out. I searched the area, went to my mother's office to look for Madeline and could not find her. so many lies there. At approximately 9:05 p.m, accompanied by law enforcement, the defendant drove his vehicle to the area he claimed to have dropped Madeline. The defendant stopped in the middle of the roadway and got out of his vehicle. The defendant claimed they were standing in the area in which he last saw Madeline Soto. During this time, law enforcement provided the defendant with Madeline Soto's cell phone. Deputy Joseph made contact with a church in that area and went through the video surveillance. At approximately 12:30 a.m, Officer Tristan Clark arrived at the home of Jennifer Soto and was greeted by Miss Soto and the defendant. Law enforcement was actively searching for Madeline something or other. By all accounts, the defendant was the last person to have seen Madeline in 2024. Or probably a date there. On February 27, 2024, at approximately 12 p.m, Detective Francis Hunt, I'm so glad they put that name in full, with the Orange County Sheriff's Office conducted an audio recorded interview of the defendant. Detective Hunt swore the defendant prior to asking him questions. The defendant reiterated that the last time he saw Madeline was when he dropped her off for school the day prior. I don't know why they even worry about doing these retractions now. During this interview, the defendant told Detective Hunt that he did not recall the exact time of the drop-off because he left his phone at home. It was also during this interview that the defendant stated that Madeline slept alone with him in the upstairs bedroom, so Jen could get better sleep. The defendant also told Detective Hunt that probably Jen was also at the residence as well when they left for school. Just guessing. At approximately 7:16 p.m, an audio recorded interview with the defendant is conducted by Detectives Myra Tagler and Lewis Acosta. The interview occurred at 4012 Santa Maria Drive. So they've got all these redactions, but they don't think to redact Jen's address. Admittedly, it doesn't have the townhouse number, but I think we all know that by now anyway. The Soto residence. The defendant was not in handcuffs and was free to leave. The two detectives who interviewed the defendant were in plain clothes. The defendant stated that he and Madeline left between 7:30 a.m. and 7:45 a.m. The defendant again reiterated that he dropped Madeline somewhere from the school the day prior. The defendant detailed their route on the way to drop her off. The defendant indicated that he tried to go to the McDonald's near Madeline's school, however he did not stop at McDonald's. The defendant estimated that he dropped Madeline off at approximately 8:20 a.m. to 8:40 a.m. At approximately 7:37 p.m, after the defendant relayed all of this information, the following exchange occurred between Detective Tagler and the defendant. Tagler, do you mind if I look at your maps real quick? Yes, that's fine. Thanks. The defendant unlocked his cell phone and handed it to Detective Tagler. There is some more clarification with Detective Acosta on the route the defendant took to reach the school and the location of where he claimed to have dropped Madeline off. I'm just going to fill in the blank here. Subsequently, Detective Tagler has the following conversation with the defendant. Tagler, do you mind if I just take a picture of your history? Defendant, yeah, that's fine. The defendant and Detective Acosta discussed what time the classes began at Hunters Creek Middle School. Their conversation continued. Detective Tagler, what kind of phone is this? Defendant, S23 Ultra, I think. Tagler, I don't know how to work this thing. Defendant, I'm sorry, I barely know how to work it myself. Except that you know how to do a factory reset now, because you've done it twice. Tagler, I'm an iPhone person. Defendant, oh. Tagler, is it okay if I go into your settings real quick? I just want to see if you're logged on to your Google. Defendant, I'm not logged on to my Google. with that, actually. Tagler, is it okay if I check? Defendant, yeah. There was some further discussion between Detective Acosta and the defendant regarding the type of digital devices, something or other, she kept them. Detective Tagler then had the following conversation with the defendant. Tagler, hold on, I don't know how to use this phone. Sorry, I don't mean to interrupt. Brief conversation occurred about somebody's behaviour. Detective Tagler, is this what you use to go places? Defendant, yes, go places, search addresses, look at store hours. Well, you didn't do it that time, did you? Write reviews. It's a pretty new phone though. It's a new phone, but you already do all those things on it, so you can't be that much of a spaz. Tagler, when did you come back to help Jen? Is that her name? Defendant, what do you mean? Because you live down south. When did you come back up north to help her? I just got here this weekend. Do you remember what day it was? Sunday. Sunday was her birthday, so yes, it was the evening after her birthday party. Sunday. Tagler, okay, do you remember what time you got here on Sunday? Defendant, 8:30ish, maybe? Tagler, okay. Defendant, just in time to make sure that she was doing all her nighttime routines, waiting for her mum to get home. Tagler, you live in Northport, right? Defendant, yeah, I split my time between the two places. Tagler, is that on Snug Street? Defendant, yeah. Tagler, that makes sense. You have a lot of Snug Street on here. Defendant, yeah, I split my time between the two. I'm not sure what's meant by you have a lot of Snug Street on here. That suggests that him saying that he wasn't logged on to Google is a lie, because she must be in his Google Maps. Detective Acosta inquired as to whether the defendant and Jennifer Soto went anywhere to look for Madeline on February 26, 2024. The defendant denied knowing whether they went to look for Madeline because he'd taken an Ativan the night before because he'd been so worried. Detective Acosta then went through the details of the directions for the route that the defendant claimed to have driven to take Madeline. The defendant then went through this discussion again, but this time included timeframes. Detective Acosta then indicated that the defendant's vehicle is not where he indicated that he was, according to the traffic cameras in the area. The defendant then indicated that he went back home because he forgot his gate clicker. At 7:53 p.m, Detective Tagler handed the defendant his phone back. Immediately after handing the defendant his phone back, Detective Tagler stepped away from the defendant. Detective Acosta stays with the defendant and they continue speaking. At 7:57, Detective Tagler returned and has the following interaction with the defendant. So we didn't see that because obviously it was only an audio recording. So it's interesting to hear that she actually had handed his phone back at that point. Right. Detective Tagler, can you unlock this one more time, please? Defendant, sure. Tagler, I have a question. Defendant, yep. Sorry, you guys done? The other detective mentioned that you didn't have your phone yesterday. Correct. Tagler, tell me about that. Defendant, I left my phone home in the morning, too. I was busy riding her, or something rather, out the door on time, that I left my phone. She left her phone. We both left our phones. Yeah, sure, so convenient. Tagler, did you have your phone when you went to the smoke shop? Defendant, not the first time after I dropped her off. I was still without it. Ugh, I got it, got my phone, and went back to the smoke shop. Tagler, okay. Defendant, later when I got home. Tagler, okay. I also noticed, I was checking your call history, I noticed that you don't have anything before this morning. Is that usual on your phone? Defendant, ugh. No, it's a new phone. Stupid. I went to do an update yesterday morning, and I don't know what the pardon me, I don't know what the heck I did, but somehow during the massive OS update I managed to factory reset my phone. Because I'm a loser. And lose all of my contacts, all my information. Tagler, What time was that, do you remember? Defendant, oh, sometime. While I was hanging out with Jen. Jen might know. I looked at her and said, what did I just do? Tagler, okay. Defendant, she might know better. I don't know what time it was. It was when I was here with Jen. Tagler, okay. I don't think I have any other questions. At approximately 7:59 p.m, Detective Tagler advised the defendant that law enforcement was going to hold onto the defendant's phone. The defendant was told that he would receive it back when we are done. It was at this point that the defendant's phone was seized by law enforcement pursuant to this investigation. After this interview ended, the defendant re-entered Jennifer Soto's vehicle and remained in the parking lot of the apartment complex. On February 28, 2024, at approximately 12:16 a.m, Detective Tagler and Detective Acosta conducted a second audio recorded interview of the defendant. During the beginning portion of this interview, Detective Tagler advised that the law enforcement had been going through Stephan's cell phone and noticed Madeline's cell phone and noticed a lot of conversations between her and the defendant. Detective Tagler asked the defendant to advise as to what type of relationship he had with Madeline. He then stated, "She thought of me as a dad, thinks of me as a dad." Less than a minute into the conversation, Detective Tagler has the following exchange with the defendant. Tagler, sorry, I don't mean to cut you off. Your phone, I told you that I was going to, hold on to it and that we would like to download your phone, right? Defendant, okay. Tagler, is this something that I have your consent to do, or do I need to get a search warrant for your phone? Defendant, it should be fine. Tagler, you're okay with us going through your phone? Defendant, yeah. Tagler, okay, can I have the PIN to your phone? Ugh, 42586. Tagler, 42586. Okay, perfect, thank you so much. Defendant, Okay, law and argument. So I think this is the bit that's going to be different in each of the documents. Consent. Warrantless searches are, per se, unreasonable pursuant to the 4th and 14th Amendments, unless there is a recognised exception to the warrant requirement. And they quote Ferrer versus State. Consent is a recognised exception of the warrant requirement. Id. The standard for measuring the scope of the consent given under the 4th Amendment is objective reasonableness. Id. The state has the burden of showing by clear and convincing evidence that the defendant's consent to search was freely and voluntarily given. For a search to be deemed involuntary, the court must find the defendant's will was overborne and his capacity for self-determination critically impaired. Okay, what they've cited here is actually relevant. The question whether a consent to search was in fact voluntary or was the product of duress or coercion, express or implied, is a question of fact to be determined from the totality of all circumstances. While knowledge of the right to refuse consent is one factor to be taken into account, the government need not establish such knowledge as to the sine qua non of an effective consent. As with police questioning, two competing concerns must be accommodated in determining the meaning of a voluntary consent. the legitimate need for such searches and the equally important requirement of assuring the absence of coercion. In determining the voluntariness of the defendant's consent to search, the court must look to the following factors. 1. Whether the defendant was free to leave. Check. Whether there was any coercive police procedure. None of that. 3. The extent of the defendant's cooperation or his awareness of the right to refuse. He cooperated, and we have 2 people stating in other interviews that he understood that he had the right to refuse. 4. Whether the defendant could have refused to consent. He could. The defendant's education and intelligence. Well, you know what, Stephan? Your mother claims you have a genius IQ. So, there you go. And 6, and this is interesting, the defendant's belief that no incriminating evidence would be found. United States versus Ramirez Chalel. Now addressing what was actually put in by the defendant. The defendant cites to the Riley versus California for the foundation of their argument that law enforcement overreached the consent given by the defendant, and Detective Tagler should have instead obtained a warrant. In Riley, the defendant was subject to an arrest for weapons violation after a traffic stop. The defendant's cell phone was in his pants pocket at the time of his arrest and was seized by law enforcement. Law enforcement searched the defendant's cell phone incident to arrest. There was no warrant for the search of the cell phone, nor was there consent from the defendant. The Riley court does dismiss many considerations when dealing with digital data. However, the defendant's reliance upon the court's ruling is misplaced. I think we're going to hear this a lot when it comes to Lizzie Burden. She just doesn't seem to get it, does she? Detective Tagler was not searching the defendant's cell phone incident to arrest. In fact, the defendant was not under arrest. Detective Tagler was viewing data on his cell pursuant to the defendant's consent for her to do so. The Riley court did not declare law enforcement must always get a warrant before searching a cell phone as claimed by the defendant. You stuffed up, didn't you, Lizzie? In fact, the Riley court recognised that even though the search incident to arrest exception does not apply to cell phones, other case-specific exceptions may still justify a warrantless search of a particular phone. One well-recognised exception applies when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. Did I not say that? Sorry, just had to gloat a bit there. The Riley court then gives hypothetical examples of exigent circumstances, exceptions, and fact-specific threats that may justify a warrantless search, such as a child abductor who may have information about the child's location on his cell phone. Oh my gosh. So, Ms. Burden quoted a precedent that within that precedent, it basically said the exception can be this, and basically stated exactly what Stephan's situation was. Oh dear, how did she get to be in that position? The scope of consent to search is generally limited to what a reasonable person would have understood to be the object of the search during the exchange between the person and the police. Law enforcement officers are not required to inform citizens of the right to refuse to consent to a search. The scope of the consensual search is determined on a case-by-case basis. The standard for determining the scope of the consensual search is objective reasonableness, i.e., what a typical reasonable person would understand the exchange of words under the circumstances to mean. Id. Limited consent given by defendant during interview with Detective Tagler. The defendant does not challenge the voluntariness of the limited consent given by the defendant during the interview. Instead, the defendant claims Detective Tagler overstepped the consent given by the defendant. The defendant's motion and argument depends on the defendant's misleading and incomplete recitation of the limited consent he gave Detective Tagler during her first interview with him on February 27. However, the defendant fails to discuss the fact that the defendant unlocked his cell phone and handed it to Detective Tagler on 2 different occasions. The defendant also fails to acknowledge that he allowed and consented to Detective Tagler viewing map data, viewing and documenting the defendant's history, reviewing settings, and viewing the associated Google account and whether it was logged in. Detective Tagler did not exceed the consent given by the defendant during the first interview that occurred on February 27, 2024. At the end of the first interview of the defendant, with the detectives Tagler and Acosta, the defendant's cell phone was lawfully seized by Detective Tagler. At the time the defendant's limited consent was given, the defendant was free to leave and did. The defendant was not in custody nor placed in handcuffs. There was no coercive police tactics or procedures utilised by Detective Tagler or Detective Acosta. The defendant provided Detective Tagler with his cell phone and unlocked it for her twice. The defendant was cooperative with law enforcement in his actions and his statements. The defendant was not specifically informed that he had the right to refuse to consent. However, it was implied in the questioning that occurred prior and during the limited search. The defendant could have refused to allow Detective Tagler to review the contents of his cell phone during the interview. The final factor for this court to consider in determining the voluntariness of the defendant's consent to search is whether the defendant believed any incriminating evidence would be found in the place to be searched. Quite frankly, the defendant believed that there would be no incriminating evidence located in his phone because he had factory reset his phone twice on the day of the homicide, believing he destroyed all the incriminating evidence. Defendant's consent to a forensic download of his cell phone. Next, the defendant's motion turns to the consent given by the defendant for the full forensic download of his cell phone. The defendant gave consent to law enforcement to download and go through his cell phone during the second interview by Detectives Tagler and Acosta on February 28. The consent was obtained from the defendant at approximately 12:17 a.m. outside the residence of Jennifer and Madeline that the defendant frequently visited. Prior to consent for full forensic download, there is no evidence of prior police misconduct or coercive tactics. And if you listen to that interview, Detective Tagler is extremely respectful throughout, as is Detective Acosta. The defendant made no attempt to limit or withdraw his consent after he gave it to law enforcement. A reasonable person would understand that giving law enforcement consent to download the cell phone and go through the cell phone would allow law enforcement access to the contents of the cell phone in its entirety. Certainly a person who claims to have an IQ that is that of a genius should understand that. During the interview in which the defendant consented to the download of his cell phone, he was free to leave. The defendant was at the home shared by Jennifer and Madeline, which he frequently visited, and was not handcuffed. The interview took place outside of the residence. The defendant argues that he was coerced into consenting to the download because law enforcement refused to return his phone and there were threats to obtain a warrant. They didn't sound like threats to me. However, the defendant's cell phone was properly seized by law enforcement, also advising the defendant that law enforcement would like to download his phone and stating, "Is it something that we have your consent to do, or do I need to get a search warrant for your phone?" Is in effect requesting consent from the defendant, as well as advising him of his right to refuse consent. Detective Tagler then subsequently followed up with the question, "You're okay with us going through your phone?" At which point the defendant responded, "Yes." There were no coercive tactics by detectives in obtaining the defendant's consent. The defendant, based upon the interactions, reasonably understood that he had a right to refuse consent. The true foundation of his willingness to have law enforcement search his phone is that the defendant believed that he had erased all incriminating evidence from his phone after he performed 2 factory resets on the cell phone 2 days prior. Law enforcement received consent from the defendant to download and review the contents of his cell phone. Law enforcement did not exceed the scope of the consent given by the defendant. Conclusion. Law enforcement legally searched the defendant's cell phone on February 27, 2024 and February 28, 2024, pursuant to the defendant's voluntary consent. Therefore, the defendant's motion seeking to suppress evidence recovered from the searches of the cell phone should be denied. Aside from a few errors at the beginning, that was a fairly good, well-written document. And it basically makes it pretty damn clear. It is stated in law that he believed, or if the defendant believed that they had no evidence on the phone, then, that's acceptable. He definitely believed that he had no evidence on the phone because he had factory reset it twice. That's going to be the sticking point here. Aside from all the other things to do with the consent, they can prove consent. They can also prove that there was no coercion. But the big sticking point here is going to be the fact that he factory reset that phone twice. Meaning that he gave permission because he believed there was nothing to find. Okay, so this one probably will be shorter because it looks like they have used the same procedural stuff. So, state's response to defendant's motion to suppress evidence obtained from unlawful seizure of cell phone. Comes now the state of Florida by and through the undersigned Assistant State Attorney and hereby states as follow. We have procedural history, which we've already gone through. Next is statement of facts, which we have also gone through. And then we have law and argument, which at this point is the same. Consensual search of cell phone during interview, and it's talking about warrantless searches, and Farrer versus State, and all that stuff that we've just read through. And then we get to seizure of cell phone. The defence heavily relies on United States versus Place in support of their argument that the seizure of the defendant's phone was unconstitutional. In Place, the court was faced with whether or not Fourth Amendment prohibits law enforcement from temporarily detaining personal property on the basis of reasonable suspicion. Law enforcement in Place detained the defendant's luggage for the purpose of a sniff test by a trained narcotics detection dog. The dog was utilised approximately 90 minutes after the initial detention and alerted to the presence of narcotics. Law enforcement obtained a search warrant 3 days later. The court's analysis was based on a seizure pursuant to reasonable suspicion. In determining whether the detention was permissible, the court must weigh the intrusiveness of a limited seizure of the individual against society's interest in detection and prevention of crime. The court also identified factors that the trial court should consider when making this determination. 1. The duration of the detention. 2. Its intrusiveness or degree to which the person's possessory interests are interfered with. 3. The diligence with which officers pursued their investigation, seeking a warrant promptly and communicating with the suspect about the specifics of the detention. And 4. The government interest or law enforcement purposes served by the detention. This is the analysis when the detention is based upon reasonable suspicion alone. The court in place also stated, and bam, how many times have you heard me say probable cause in relation to this phone? Where law enforcement authorities have probable cause to believe that a container holds contraband or evidence of a crime, but have not secured a warrant, the court has interpreted the amendment to permit seizure of the property, pending issuance of a warrant to examine its contents, if the exigencies of the circumstances demand it, or some other recognised exception to the warrant requirement is present. In other words, in this case, it was urgent, they had a missing child, they didn't know if she was still alive. There's your exigencies. In the instant case, the item seized by law enforcement was the defendant's cell phone. The Supreme Court has interpreted the Fourth Amendment to allow a warrantless seizure when law enforcement can show both probable cause to believe that property contains contraband or evidence of a crime, tick, an applicable warrant exception, such as exigent circumstances, i.e. a missing child, exists. United States versus Babcock. Probable cause to seize the defendant's cell phone. The first prong in the analysis for the court is to determine whether Detective Tagler had probable cause at the time that the defendant's cell phone was seized. The seizure of the cell phone occurred at approximately 8 p.m. on February 27. Probable cause merely requires that the facts available to the officer would warrant a person of reasonable caution in the belief that certain items may be useful as evidence of a crime. It does not demand any showing that such a belief be correct or more likely true than false. A practical, non-technical probability that incriminating evidence is involved is all that is required. Given all his lies and everything else, yep. Probable cause only requires a substantial chance that there is evidence of criminal activity. The courts have also found that a substantial chance exists where the facts within the collective knowledge of law enforcement officials suffice to cause a person of reasonable caution to believe that a criminal offence has been or is being committed, and that evidence of that offence will be found in a particular place. And let's acknowledge that at that point in time, they pretty much already did have him banged to rights. Okay, moving on. Detective Tagler and members of law enforcement had probable cause to believe that there was evidence of a crime contained in the defendant's phone at the time of the seizure. At the time of the seizure, the following information was known to law enforcement. Madeline Soto, a 13-year-old child, had been missing for over 24 hours, and the first 24 hours are crucial. 2. The defendant was consistently identified as the last person to have seen Madeline prior to her disappearance. That should be all it takes. 3. Law enforcement had tag reader evidence that the defendant was not being truthful with regard to his movements on February 26, including when and where the defendant claimed to drop Madeline off at school. 4. Madeline never arrived to school on February 26. 5. The defendant factory reset his phone on February 26, 2024. 6. The defendant was alone with Madeline in a bedroom the night prior to Madeline's disappearance. When you start adding it up like that, it doesn't look good for him, does it? 7. The defendant regularly utilised his cell phone to speak with Madeline. 8. The defendant, when confronted with inconsistencies which evolved in his statements, began adding additional explanations. 9. The defendant had his cell phone with him during a portion of the day on February 26. 10. The defendant regularly used location data and internet on his phone. And 11. The defendant's phone was attached to the defendant's Google account, even though the defendant denied being logged in. Collectively, these circumstances gave law enforcement probable cause to believe that the defendant had committed a crime against Madeline and that evidence of the crime would be found in the defendant's cell phone. And boy was it. Exigent circumstances, and this is probably even more important. The 4th District Court of Appeal in State v. Data cited to the Supreme Court when considering exigent circumstances, the test of whether exigent circumstances exist is an objective one. Whether exigent circumstances exist in a given case is a fact-specific inquiry that depends on the totality of the circumstances. When considering the exigent circumstance of imminent destruction of evidence, objective test applied by the courts is as follows. The government must show more than a subjective fear of imminent destruction of evidence. The fear must be objectively reasonable. In determining whether the agents reasonably feared imminent destruction of the evidence, the appropriate inquiry is whether the facts as they appeared at the moment of entry would lead a reasonable experienced agent to believe that evidence might be destroyed before a warrant could be secured. In other words, were the police unreasonable in not getting a warrant in the circumstances that confronted them? Well, let me see. 2 factory resets of that phone. What do you think? Courts have found the exigent circumstances exception particularly compelling in cases dealing with electronic files. In Bradley, the court found exigent circumstances permitting law enforcement to shut down servers in order to prevent employees from destroying evidence. Detective Tagler, along with other detectives of the Orange County Sheriff's Office, had an objective fear of the imminent destruction of the evidence contained on the defendant's phone. The defendant had been evasive and deceptive in law enforcement interviews and was untruthful regarding the whereabouts the morning of Madeline's disappearance. The defendant had already attempted to destroy evidence contained on his cell phone by factory resetting the phone at some point during the late morning hours of February 26. Although the cell phone had been factory reset, there were still exigent circumstances supported by an objective fear of further destruction of evidence by the defendant. The defendant was also aware that law enforcement was interested in determining the Google account associated with the phone. The defendant was aware at that point that law enforcement had evidence that contradicted his claimed movements on February 26. It is reasonable to believe that the defendant knew he was under suspicion once Detective Tagler and Detective Acosta confronted him with the inconsistencies and showed interest in the information contained on his cell phone. It is also reasonable to conclude that the defendant had the ability and incentive after the interview with Detective Tagler and Detective Acosta on February 27 to further destroy incriminating evidence contained on his phone. Conclusion. Law enforcement legally seized the defendant's phone on February 27 after developing probable cause that there was evidence of criminal activity contained on the defendant's cell phone, and exigent circumstances existed that the defendant would further attempt to destroy evidence contained on the cell phone. Therefore, the defendant's motion seeking to suppress evidence recovered from the seizure of the cell phone should be denied. So I was a little bit wrong in terms of exigent circumstances. I thought that would have referred to the missing child, but I get what they're saying there. So he had been untruthful with them. They had evidence of his lies. He knew they had evidence of his lies, and he'd already attempted to factory reset the phone. So they can definitely show that there was a risk of him destroying the phone or doing something to it to make it harder for them to recover any evidence that was on the phone. And of course, based on the first two documents, this one's going to be a slam dunk. State's response to defendant's motion to suppress evidence obtained from Google search warrant. Comes now the state of Florida by and through the undersigned Assistant State Attorney and hereby states as follows. Procedural history, which we've read. Statement of facts, which we've also read. Okay, so we have burden of proof. The defendant's motion cited to Florida Rule of Criminal Procedure and as grounds for suppression of the Google search warrant return evidence. Pursuant to Florida Rule of Criminal Procedure, if the court hears the motion on its merits, the defendant shall present evidence supporting the defendant's position, and the state may offer rebuttal evidence. When evidence has been obtained by law enforcement pursuant to a warrant that was issued, the burden is on the defendant to establish grounds for suppression. The allegations set forth in the defendant's motion are not evidence, and the defendant shall present evidence supporting his position at a hearing. So I would have to go back and look at the warrant, the thing for the warrant, but it sounds like they're basically saying that they've done it wrong. If need, I will bring up that document after this, but this will probably become self-explanatory, I'm going to guess. Standard of review. Law enforcement obtained a search warrant prior to searching through the defendant's Google LLC account information. As such, the defendant is challenging the search warrant issued for this information. The trial court's role in reviewing the decision of the Honourable Circuit Judge Whitehead is to ensure that there was a substantial basis for concluding that probable cause existed. Probable cause is established when two elements are set forth in the affidavit for the search warrant. The commission element, a particular individual has committed a criminal offence, and two, the nexus element, evidence that is relevant to the probable criminality is likely located at the place requested to be searched. State versus Williams. And they've got two things cited there, State versus Suburban. Courts reviewing the probable cause determination of another judge or magistrate should afford great deference to that decision. A grudging or negative attitude by reviewing courts toward warrant is inconsistent with the Fourth Amendment's strong preference for searches conducted pursuant to a warrant. Courts should not invalidate warrants by interpreting affidavits in a hyper-technical rather than a common-sense manner. In other words, trying to overthink it and come up with all these technicalities, if there is actual just common sense evidence, is basically against the Fourth Amendment. The trial court should not disturb an issuing magistrate's determination absent a clear demonstration that the magistrate abused his discretion in relying on the information in the affidavit supporting the warrant application to find probable cause. So what they're going at here is basically saying the warrant was approved by a judge. The judge reviewed the request for the warrant in which there was probable cause, and for another judge to basically say that the warrant wasn't correct is basically going against the other judge. So the state was basically going against the prosecution in trying to say that this warrant wasn't legit and needs to be thrown out. But the legalities of it is that they are, in essence, going after another judge. Law and argument. Probable cause developed during consensual search. The legality of the searches and seizure of the defendant's cell phone is discussed in State's response to the defendant's motion to suppress evidence obtained for an unlawful seizure of cell phone, and State's response to defendant's motion to suppress evidence obtained from unlawful searches of a cell phone. As such, the State's position is that the evidence obtained from the defendant's cell phone was legally obtained by law enforcement. Law enforcement relied on information obtained during the consensual search of the defendant's cell phone to support the probable cause recited in the affidavit for the search warrant related to the defendant's Google information. Therefore, the exclusionary rule as fruit of the poisonous tree is inapplicable to the Google information obtained pursuant to the search warrant. The affidavit for search warrant establishes probable cause. When reviewing an affidavit for search warrant, the probable cause determination must be made by examining the four corners of the affidavit. Pagan versus State. Conclusory statements or bare conclusions are insufficient to support a finding of probable cause by a judge reviewing an affidavit for search warrant. See Gosel versus State. In Gosel versus State, the issuance of a search warrant was challenged by the defendant, claiming that the affidavit was insufficient to support probable cause. The affidavit indicated that a photo was reviewed by the affiant. The affiant determined that the photo did in fact depict CP. The affidavit lacked any information to independently determine whether the photo constituted CP, as opposed to lawful non-obscene nudity. The affidavit also failed to demonstrate any training or expertise in identifying CP that the affiant had. The affidavit stated he was in the intelligence section and conducted digital forensic examinations. The affidavit further detailed that he had history of involvement in CP investigations, was a member of the Central Florida Internet Crimes Against Children's Task Force, and conducted investigations related to possession of and transmission of CP. The court found that all of the training listed was technology-related training. The court found that the affidavit was insufficient to support probable cause to issue a warrant. In State v. Neela, the court addressed arguments that a search warrant affidavit was insufficient to support a probable cause finding relating to allegations of possession of CP. Detectives received a NCMEC cyber tipline report regarding 4 images uploaded by a specific IP address. The detectives confirmed that the IP address was registered to McNeela. Law enforcement conducted an interview at which time McNeela provided consent to search his computer, of which he was the primary user. The external hard drive plugged into the computer was also searched as part of the consensual search, at which point law enforcement seized the computer and hard drive and sought search warrants. In the affidavit for search warrant, the images sent in the original tip were described in graphic detail. Law enforcement classified the images observed during the consensual search as CP. None of the images observed by law enforcement during the consensual search were described, nor were any identified as being an image related to the original tip. The court found that the warrant affidavit contained sufficient probable cause. In State v. Wooldridge, the court again addressed allegations that a search warrant affidavit was insufficient to support probable cause finding relating to allegations of possession of CP. Detectives received a NCMEC tip regarding a specific AOL user attempting to email files containing CP. The affidavit for search warrant detailed the investigation relating to Wooldridge being linked to the subscriber information for that screen name. The detective indicated that they viewed the images related to the tip and also detailed his background in the investigation of online CP cases. The Wooldridge opinion gives no indication that the affidavit there described the images themselves. Instead, the affidavit relied on the officer's training and experience to establish their nature as contraband. The Wooldridge court reversed the trial court's order granting the suppression of evidence seized pursuant to the search warrant, finding that the conclusion the affidavit did not establish probable cause was incorrect. In State v. Peltier, the court again addressed the sufficiency of an affidavit for search warrant relating to an investigation into the crime of possession of CP. The affidavit for search warrant detailed files that were uploaded from the defendant's computer with hash values previously identified as CP. The affidavit identified videos and images of CP and child ER on Peltier's computer shared through peer-to-peer networks. Images and videos obtained from Peltier's computer, as detailed in the affidavit, contains files depicting the female child victim doing stuff, and I'm not going to read any of that because I just don't want to go there. The court stated, "Our record reflects that the various media contained in Mr. Peltier's computer and offered through BitTorrent to the public included images of these descriptions cannot be confused with innocent content. In the case at hand, there is a substantial basis for concluding that probable cause existed to support the issuance of a search warrant for Sterns' Google account. As was the case in Peltier, the description given by Detective Heller in the affidavit for search warrant cannot be confused with innocent content. Detective Heller specifically identified Madeline, 13 years old at the time the affidavit was drafted, as being depicted in several files of child SA material. Nexus between the Google account and criminal activity. An affidavit for search warrant detailing probable cause must provide information supporting the probability of the evidence of the crime will likely be located in the place to be searched. To satisfy the nexus element, the affidavit must establish the particular time when the illegal activity that is the subject of the warrant was observed. A magistrate is not required to leave common sense at the courthouse door when evaluating whether a supporting affidavit satisfies the nexus element and supports a finding of probable cause. In the affidavit for search warrant, Detective Heller indicated that the current investigation began on February 26, with Madeline Soto being reported as missing. Detective Heller indicated that interviews were conducted, mentioning an interview specifically of the defendant. The affidavit details the statements the defendant made about dropping Madeline off on Monday 26. The affidavit also reflects that the defendant consented to a search of his phone and also stated he performed a factory reset on his phone. On February 26, during a search of the defendant's cell phone, several files of child SA material involving Madeline were located. It was also stated that the defendant's images were stored and backed up on his Google account, sustanet@gmail.com. Further, Detective Heller discussed the Google Drive and the storing of photographs from smartphones. Finally, the affidavit for search warrant was authored by Detective Heller on February 28. The affidavit for search warrant for the defendant's Google account provided a sufficient basis for the Honourable Circuit Judge Whitehead to determine that evidence related to possession of CP would likely be located on the defendant's Google account. The affidavit mentions that the defendant factory reset the cell phone on February 26. The defendant then provided consent to search his cell phone. Files of child SA material involving Madeline were located on his cell phone, and the images were backed up on a Google account, specifically sustenance@gmail.com. Also, the affidavit for search warrant supported a probable cause finding that evidence related to interference of child custody was contained within the defendant's Google account. Detective Heller detailed that 13-year-old Madeline, as reported by her mother on February 26, an extensive search and interviews were conducted. The defendant stated that he dropped Madeline in front of the Peace United Methodist at approximately 8:40 a.m, even though classes did not begin at Hunters Creek Middle School until 9:30 a.m. A license plate reader captured the defendant's vehicle tag travelling away from that area at 8:10 a.m, not to school. The defendant backed up images from his cell phone to his Google account. It is probable that other information on the defendant's cell phone prior to the factory reset was backed up as well. We didn't know that bit of information, did we? So before he factory reset his phone, he actually backed it up. Google maintains GPS data and other data, which was described in the affidavit for search warrant. Located as of the submission of the affidavit for search warrant, the defendant's movements and activity that may have been backed up onto his Google account support a nexus that evidence related to the interference of child custody would be located. Generalised language about Google account services. The implementation of standard language grafted into a search warrant related to the operations of Google LLC is helpful and relevant in the affidavit for search warrant. Law enforcement does not need to reinvent the wheel for every application. And this background information is accompanied by case-specific information. Temporal component of the affidavit for search warrant. The observation that images of CP are likely to be hoarded by persons interested in those materials in the privacy of their homes is supported by common sense and the cases. Since the materials are illegal to distribute and possess, initial collection is difficult. Having succeeded in obtaining images, collectors are unlikely to quickly destroy them. Because of their illegality and the imprimatur of several social stigma such images carry, collectors will want to secure them in secure places like a private residence. This proposition is not novel in either state or federal court. PDF files, preferential child emirs, and CP collectors maintain their materials for significant periods of time. Whole heap of statute and precedent there. In this case, there was evidence to support the defendant was an individual that fell into this category by the information that the child in the SA material was the defendant's, they've got it in quote marks, so I'm thinking they're going to say stepdaughter, which I hate. And the material was located on his cell phone and back up onto his Google account. Particularity. The Fourth Amendment requires that warrants particularly describe the place to be searched and the person or things to be seized pursuant to it. The particularity requirement prevents the seizure of one thing under a warrant describing another. If there is indeed probable cause to believe the fruits or instrumentalities of crime are to be found in a particular place, the warrant applicant should be able to explain to the magistrate with some specificity what those items are. In Lamb, the defendant challenged the warrant as lacking particularity when it sought all stored files in original format in individual files. The court determined that although the language does not limit investigators to seizing image files only or image files of CP only, the actual content of a computer file usually cannot be determined until it is opened with the appropriate application software on a computer. Any overbreadth in the warrant did not taint the remaining portions that were not overbroad. In the case before the court, the application for search warrant for the defendant's Google account information was not overly broad. The affidavit for search warrant elicited specifically what was being sought by law enforcement in relation to the warrant and investigation. Good faith exception. When a law enforcement officer acting with objective good faith obtains a search warrant and acts in accordance with the warrant and its scope, suppression of the evidence obtained is not appropriate if a reviewing of court later determines there was not probable cause. Exclusion is appropriate in cases in which the issuing judge was misled by information the affidavit knew to be false or would have known to be false but for reckless disregard of the truth. In other words, had they lied in the request for the warrant, that would be inadmissible. Exclusion is also appropriate in cases in which the affidavit is so lacking in probable cause that any reliance on it would be unreasonable. I think they showed enough probable cause, clearly. So neither of those things have been shown by the state, by the defence. Even if the court determines that the affidavit for search warrant of the defendant's Google account was insufficient to support a finding of probable cause, law enforcement acted in good faith reliance on the warrant that was issued. Law enforcement did not provide any information in the warrant that was false or misleading in the affidavit for search warrant. Also, the search warrant was not lacking as to make any reliance on the warrant unreasonable. Conclusion: law enforcement drafted an affidavit for search warrant for the defendant's Google account information that sufficiently set forth probable cause for the search. Therefore, the defendant's motion seeking to suppress the evidence obtained from the Google search warrant should be denied. And they also, in this document, obviously have shown that the seizure and search of the phones was legal. But let's say hypothetically that the seizure and search of the phones wasn't legal. What this document shows is that it doesn't count as that fruit of the poison tree, because they've clearly shown adequate probable cause for the judge to make a ruling, yes, you have this warrant, you can access the Google Drive. So the point is, the judge saw the application as sufficient. They provided enough probable cause, and in good faith, that meant that they were able to access the Google Drive. So all I have to say to Ms. Borden is stick that in your pipe and smoke it. So that brings us to the end of those three documents. I think a few standouts for me is that once again the defence have misinterpreted statute and precedent and are quoting cases without really looking at the entire case. Doesn't look good for them. They also, I think we can see that the state has proven that the seizure of the phone and the download of the phone was justified. And especially given that he had already done 2 factory resets on that phone. His lies and his actions have not helped him at all here. And as for the warrant for the Google account, it's good to know that regardless of the phone stuff, at the end of the day, the judge gave that warrant, and it's frowned upon for another judge to basically then go against another judge. It's basically not supported by law unless there is a significant issue. That said, there were no lies in the warrant. They proved probable cause. So the warrant was just. And of course, they acted on good faith because the judge gave them the warrant to access the Google accounts. So I think we can feel quite confident that none of the phone stuff is going to be an issue, and the Google Drive is not going to be an issue. And yes, you can tell that I've done 2 videos back to back today because my voice keeps going. The other thing that I'm taking away from this is that I think Stephan's goose is cooked. When we look at the capabilities of the defence alongside the capabilities of the state, and don't forget, this is Danielle Pennell. She tried the case, the Todd family murders. She was the prosecutor there with Judge Carson. So she knows what is expected by Judge Carson. They've got that professional relationship already. And I think we've seen in all the filings so far from the state that in terms of skill sets, they seem to be way ahead of the defence. I mean, that's just my opinion, but it's certainly the way it appears to me. When you compare the waffly, sometimes irrelevant documents from the defence team to these well outlined documents from the state, there's a huge difference. Huge difference. And so far, every response that we've seen from the state has pointed out where the defence has got the law wrong. And that's going to be an issue for them if they keep doing that when it comes to trial. So on that note, before my voice completely gives out, thank you for listening. If you are new to my channel, please do subscribe. Also, hit the like button and leave a comment below. Thank you, and I will catch you in the next one.